Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Morning. Another new court ruling here. Again, this is from a few months back because I'm a little behind. Anyway, thank you to Adriana De La Torre because she provides these great summary reads. And I enjoy sharing them and learning from them. Okay, so this one, guys, is an 11th Circuit case. As I've said previously, I think opinions from all circuits are helpful in any other circuit as a general rule. It's not necessarily binding, but I find that they oftentimes will appreciate it themselves if another ruling has been very explanatory. Of course, it's they're usually so case specific. It won't necessarily help in a particular way, but they tend to drive home things that are even in rulings. So, and those things apply to all circuits. Okay, so this is Micaud, and it involves vocational classifications and residual functional capacity evaluations. So this particular claimant, Micaud, and I don't know if I'm pronouncing that right. It's Micaud. I will try to link this summary to you guys down below. There were two key arguments that this claimant made. He argued that, and by the way, he did not succeed, but he argued that the ALJ failed to classify his past relevant work as a composite job. Now, a composite job is one that is a mix of kind of like two different jobs. So you're almost doing a little bit of both. In this case, it was a mix of commercial photography, so a photographer in the commercial setting, and then a photographer helper roles. It's funny because this year I had a photographer with her own business, and it wasn't all just, being on the pedestal, taking the finest of shots. There's a lot of heavier work to it, setting up displays, things like that. Okay. The ALJ's RFC, this is what the claimant argued, wasn't supported by the substantial evidence, particularly regarding his physical and mental limitations. So the substantial evidence argument, it's very vague, but we've seen a couple winners with it recently in some of these court hearings, court decisions, when someone appealed their hearing. Okay, so the composite job classification, we were reminded that, well, in this case, the claimant said that his past work included significant elements of two different roles, making it a composite job. And that distinction matters because composite jobs don't have clear counterparts in the national economy, which could then have changed the outcome. Because if you might recall, um, the jobs that we look at have to exist in substantial numbers in the national economy. So if it's a composite job mixed of two, and therefore doesn't have its own DOT listing, etc., it might make a different ruling then because there might not be a job that you could apply to that person, that finding that they could do that exists in substantial numbers. But unfortunately, the circuit court disagreed with the claimant. The circuit court said that the lack of evidence connecting Micaud's unique tasks, for example, lifting heavy weights, to the significant elements of a photographer helper's role. So again, I didn't read this decision. I wonder what lack of evidence there was. Like, did he just claim he lifted heavy weights, but then didn't describe what it was? Then I wonder, though, did anybody ask him more specifically? Did the judge? I don't know. They do go on to say that the legal burden is on the claimant to prove composite job status. So that goes to say then that if you think you have a composite job, which can be beneficial to a determination in your favor, the legal burden is on you to prove that it is a composite job, that it actually has a mix of like two different jobs, photographer, photographer's helper. Sometimes we see these things in office manager, but the office manager is doing things like filling the copy machine, um, could be checking the bathroom to make sure it's clean. That's kind of not necessarily what we think of as an office manager, so it could have composite markings on it. She goes on to say that with the RFC assessment issue, the claimant argued that the ALJ failed to properly evaluate his physical and mental limitations, but the court found otherwise. It said that the ALJ had appropriately used the psychiatric review technique, determining only mild mental limitations. So remember, they use the psychiatric review technique, like an internal medical expert, to look at all the mental health records and everything that would point to the extent of mental limitations that stem from the mental impairments. And when it's only mild, it's not going to have much effect on your case, particularly uh, if it doesn't change anything with regard to, say, grids or what have you, or prior work. The medical evidence, particularly the records before the claimant's date last insured, supported the ALJ's conclusion that his impairments did not significantly limit his ability to work. So what they're saying here is Micaud, he had a date last insured that was in the past. We talk about this all the time. The difficulties you add to your case, oftentimes by allowing your date last insured to expire. The longest we ever have of a date last insured in the future is 5 calendar years after we have stopped working. As you know from other videos, you can prevent that by working very part-time, whether seasonally or just a little here and there every month of the year to keep your credits coming in, your earnings credits. So definitely something to always be aware of if you're claiming, particularly if you've waited a few years before applying. It always worries me when I see a potential client and it's been like 3 or 4 years since that person stopped working, if they haven't been doing part-time something in between. If they have, they're usually really saving themselves. Little do they know. Not only do they bring in a few bucks, which by the way can be under SGA, and it can still suffice to get your earnings credit so you never have a remote in the past DLI, date last insured. So here it looks like the medical evidence before his date last insured was not very indicative of significant mental health challenges or symptoms. Maybe it became so after, but that's the important thing to remember about DLI. They can't look at what comes after the DLI in terms of finding the disability to have started. So you really have to pay attention to that date. If you can avoid having a past DLI, I would do so. It could be doing your own little side business. You don't have to make that much. 7,000. I think it'll be something under 7,200 for 2025. A year will get you all 4 credits. And typically even 2 credits a year can keep you insured if you're not otherwise going to be if you don't have previous big gaps of a whole year without credits. But if you can do the 4 years, it's a little safer. It keeps you extended out for, the longest, generally speaking. So Adriana's key takeaways are: when arguing the composite job issues, it's vital to document detailed job duties and their alignment or misalignment with the DOT. A vague claim won't suffice, and referencing, and I'm going to give you the number here, the POMS DI 25005.020 is crucial. And that we should always push back on vocational experts who fail to consider discrepancies between a client's actual work and the DOT definitions. Now, it'll be interesting. We're talking about the DOT, but there's been some recent policy changes with how they're going to be looking at vocational matters and a change up from the DOT. And I haven't quite gotten my claws into that yet, but it's one of the things I plan to do this holiday pseudo time off, which isn't really time off. Okay, because it's going to be really probably pretty important. Any event, composite jobs, guys, something to think about. If you had a composite job, it's something to develop that evidence on when you're doing your work history report. You're going to want to really go to town on that, make sure it's clear. And keep an eye on that DLI. Because if his mental health problems became severe, but they weren't severe before his DLI, that's not going to be entirely helpful, not in terms of trying to find that onset date he needed for total disability. And it looks like he lost, and that could have been part of the reason why. between that and, not succeeding on the composite job argument. All right. There you go. Micaud, if I'm saying that right. Have a great one, guys. I'll talk to you later. Bye.